Good morning friends, I am Dr. Yogesh Pratap Singh, Assistant Professor of Law at National Law University, Orissa, Cuttack, but right now I am on leave for 1 year and I am heading an institution in Saharanpur. This is called Global Law School. Today's lecture is on Ronald Dworkin. In this module we will be covering following aspects related to the process of adjudication. We will see the various divergent views on process of adjudication. For instance, what is the opinion of the people who belong to realist school, what is the opinion of Professor H.L.A. Hart who takes a midway, and what are the criticisms offered by Professor Ronald Dworkin on the process of adjudication as suggested by the realist school. We will be also discussing the rules with the help of few illustrations. Two we have selected from the cases decided by the American courts and two of such cases decided by the Indian Supreme Court we will discuss, and we will try to understand the process of adjudication and the concept of determinacy and indeterminacy of law. Now we will start with the module. The process of adjudication is very crucial for any legal system. Judiciary is a wing, is an important wing of the state which does the adjudication or settlement of the dispute, and in doing so they apply law. Now there are divergent views on the process of adjudication, means how judges decide cases, how do they decide a case, and some people say that law is indeterminate to the extent that legal question lack a single right answer. In the process of adjudication, law is indeterminate to the extent that authoritative legal materials and methods permit multiple outcomes to lawsuits. Over the years, to many commentators like jurists who belong to realist school, critical legal school, they became a very caricature solely for the claim that outcome of the judges was only a matter of what the judges had for the breakfast. It simply makes it clear that there are divergent views on determinacy. On one hand, or on one extreme, we have realists who believe that law was rationally indeterminate in the sense that available class of legal regions did not justify a unique decision, and second, that the law was also causally indeterminate in the sense that legal regions did not suffice to explain why judges decide as they did. Now we come to Professor H.L.A. Hart, who in his famous book The Concept of Law, he mentions, or he argued, there are some cases in which the rules of a legal system do not clearly specify the correct legal outcome. Hart claims that such cases arise because of the ineliminable open textures of the natural language. He thinks that because of this open texture there is a duality of a core of certainty and a penumbra of doubt when we are engaged in bringing particular situation under general rule. This imparts to all the rules a fringe of vagueness or so called, what he says, open texture. Briefly, Professor Hart argues that when a case arises within the concept, within the open texture of a legal rule, a judge exercises discretion, and this discretion was exercised by the judge to make a choice between open alternatives, and thus he engages in a creative or legislative activity. This is how judges make creative interpretation or they legislate. Professor Hart saw legal indeterminacy as a peripheral phenomena in a system of rules which by and large does provide a specific outcome to cases. Now, we come to Professor Ronald Dworkin, who was a professor at University of New York, professor of law and professor of jurisprudence at the Oxford University. He, in his famous book Taking Right Seriously, he argued that even the amount of indeterminacy which Professor Hart argued or allowed was also exaggerated. Dworkin strived to show that in most of the legal cases, even in hard cases, he gave the concept of hard cases where there is a deep and intractable disagreement over what the law requires, right answer can be found by searching in regions and imaginations, and hence there is no indeterminacy or there is no underdeterminacy. He says that if law were simply a collection of rules as hard things, it would be afflicted by exactly the kind of deep and pervasive indeterminacy which the realist posits. Yet, if the law were indeterminate to the degree suggested by the realist analysis, it would not be much more than a pious fraud, where judges would be legislating not only in the penumbral cases, but in all the cases. Judges should apply law, and that institutions which other institutions have made. Law making is the primary function of the legislature, not the judiciary. They should not make new law. This is the ideal situation, but for different regions it cannot be realized. Even Professor Dworkin accepts that this is the ideal situation where judges has to apply law, should apply law, but this cannot be realized fully in practice in all the cases. Statutes and common law rules are often vague and must be interpreted before they can be applied to novel cases. Some cases moreover raise issues so novel that they cannot be decided even by stretching or reinterpreting existing rules. This is in his opinion are the hard cases. So, judges sometimes makes new law either covertly or explicitly. He further argues that judges are never free to exercise strong discretion in deciding issues of law, even in cases in which no legal rule dictates a clear result. When a judge runs out of textbook rule, there is no textbook rule found, the Dworkin he asserts he must base his decision not on a legal standard, non-legal standard or norms, but rather on what may be called legal principles. Legal principles in Dworkin's opinion are as much a part of the law as our black letters rule, and are equally binding on the judges. In those cases which the legal rules did not clearly decide the case, it was the principle that would guide judges to determine the outcome. Now, he gives the concept of principle. So, in the absence of a legal rule, clear rule, judges can apply principles to determine a case. Moreover, while no single principle is dispositive of a given cause, a fair consideration of all relevant principles points to a uniquely correct answer even in hardest of cases. Even in hardest of thesis, famous Wright thesis, he argued that judicial decision in civil cases, even in hard cases, are and should be generated by principle, not policy. The Wright thesis provides that judges decide hard cases by confirming or denying concrete rights after considering all relevant principles. Since there is only one correct adjudication of rights in every case, one litigant always has right to win, a right that Dworkin views as a genuine political right. He also distinguishes the policy and principle debate. What is the difference between policy and principle? He says that policy is a standard that sets out a goal to be reached, generally an improvement in some economic, political or social feature of the community. Principle is a standard that is to be observed not because it will advance or secure an economic, political or social institution deemed desirable, but because it is a requirement of justice or fairness or some other dimensions of morality. Thus, the standard that automobile accidents are to be decreased is a policy, and the standard that no man may profit by his own wrong is a principle. He also provided certain illustrations to make this policy and principle distinction clear, and two of the cases which we have selected are decided by the American courts, and two of the cases which we will discuss are the decisions, leading decisions of the Indian Supreme Court. The first case where we can decide this policy and principle distinction was Elmer's case, Ricks versus Palmer, 22 NE 188 1889. The facts of this case are as follows. The deceased Mr. Palmer made a will to his grandson, the defendant of his estate. After that, Mr. Palmer remarried, and because of that the defendant was afraid that his grandfather may change his will at any time and he will get nothing. Therefore, he decided to murder Mr. Palmer, and finally he was convicted and was sentenced to imprisonment for a couple of years. Now, the question before the court was whether the defendant should be legally entitled to will after he came out of the jail. Now, if you see the law, black letter law, according to the New York State Statute, there will be this will prepared by his grandfather was valid and the defendant was entitled to it. However, eventually the majority of the court decided the case against the defendant, and they based their arguments on a long established principle, and this principle was no one should be permitted to profit by his own fraud or to take advantage of his own wrong. This was a principle which was applied by the court in the absence of any express legal rule. This is a principle of equity which was developed by the chancellors equity courts in England, that a person who wants equity must come with clean hand. So, no one should be permitted to profit by his own fraud or to take advantage of his own wrong. This principle was applied by the judges, majority of the judges in this case, and the judges decided that the person defendant will not get, cannot take the benefit of his own wrong, because he murdered his grandfather and he cannot take benefit, he cannot take the properties of his grandfather from his will. The second illustration which we can offer is a famous case decided by the Supreme Court of New Jersey, is Henningsen versus Bloomfield Motors. The facts of this case are as follows. The plaintiff Mr. Henningsen purchased a new automobile from defendant Bloomfield Motors. He also signed a contract which provided that the manufacturer's liability for defects was limited to making good defective parts. So, his liability was limited only to defective parts which he will rectify. This warranty was expressly in lieu of all other warranties, obligations or liabilities. 10 days after the purchase, while his wife was driving the car, the steering mechanism of the vehicle failed, and which resulted in an accident which damaged the car. Now, his wife sued both Bloomfield and Chrysler, Subsequently, her husband also joined the action seeking recovery of the consequential losses. Now, both the claims were based on alleged breach of implied warranty of merchantability imposed by the Uniform Sales Act 1906. The defense in this case relied on a contractual disclaimer of warranty which the Sales Act would permit. This disclaimer was printed on the back side of the contract and extremely in small letters. It was extremely a small print. It purported to limit liability for any breach of warranty to replacement of defective parts within 90 days of the sale or before the car had been driven 4,000 miles, whichever period was shorter. The sales contract was printed on one page, front and back, which the most of the front print in 12 point type. After the signature portion, we find that the type became much smaller. So, contract was in bigger font, and after the contract ends, you will find a very smaller fonts. The final two paragraphs printed on the front of the contract attested that the agreement was complete, that the signers were over the age of 21 and that the signers had read the matter printed on the back side of the contract and they agreed to it as a part of this order, the same as if it were printed above my signature. Now, plaintiff testified that he did not read the final two paragraphs or any of the printed material on the back of the form. Now, decision of this court was very difficult. The New Jersey court, finding no applicable rules, decided that automobile manufacturers could not claim limited liability for defective products and the damages caused by them. The court based its decision on the principle that automobile manufacturers have a special obligation in connection with the construction, promotion and sale of his cars, because among other reasons cars are so essential. Consequently, the courts must examine purchase agreements closely to see if consumers and public interest are treated fairly. The third case which we have selected to make you understand the distinction between policy and principle and how judges decide cases in the absence of a black letter law, a clear rule, was a famous case decided by Indian Supreme Court in the year 1973, and this famous case was Keshwanand Bharti versus State of Kerala. This dispute was related to the power of the parliament to amend the constitution, and this dispute arose in the very first year of this constitution was implemented, Indian constitution was implemented, and the matter was brought before the Supreme Court that what is the extent of power of the parliament under article 368 to amend this constitution. And the Supreme Court in the earlier cases, for instance Sajjan Sankari Prasad Singh Dev versus Union of India and Sajjan Singh versus State of Rajasthan, the Supreme Court decided that the power of the parliament to amend the constitution under article 368 is a constituent power, is unlimited power, is plenary power, and there is no such limitation, there is no limitation imposed by the constitution. But in the second case after Sankari Prasad Singh Dev, the second case which decided that 17th Constitutional Amendment Act was valid, and the 2 out of 5 judges, the decision was given by the majority, though all the judges agreed on the question that 17th Constitutional Amendment is valid, but the 2 judges raised serious doubts on the majority opinion. This was a concurring opinion by Justice Hidayatullah and Justice J.S. Madhulkar, where there is serious doubts on the reasoning given by the majority, and they said that if this is the interpretation of article 368 vis-a-vis fundamental rights, that they have all powers to abrogate fundamental rights, they have all powers to change the constitution or even to rewrite the constitution, then we have serious doubts that whether this was the intention of the drafters. If this was the intention of the drafters, then fundamental rights, which is the most sacrosanct part of our constitution, will be a playthings in the hands of majority. And this was the time, for the first time, the Indian Supreme Court gave the idea of basic structure in Sajjan Singh versus State of Rajasthan. Justice J.S. Padholkar, he said that there are some features of the constitution which constitute basic structure of the constitution, basic features of the constitution, and which cannot be changed, by using the power of amendment under article 368. This was the effect of these doubts created by these two judges. The same matter was again referred to the constitutional bench, larger bench, an 11-judge bench in I.C. Golaknath versus State of Punjab overruled earlier two decisions, Sankari Prasad Singh Dev and Sajjan Singh. Now, in 11-judge bench headed by Justice Subba Rao decided that the power of parliament under article 368 is not a constituent power, it is a ordinary legislative power, because word power was not mentioned in article 368, and in the original constitution article 368 marginal note provided only procedure to amend the constitution. So, applying literal rule of interpretation, Justice Subba Rao said that power is not vested in article 368, and power we have to derive, parliament has to derive from article 245 to 248. Now, if we come to 245 to 46, you have to read schedule 7, and schedule 7 there is no such subject like amendment of the constitution. Justice Subba Rao suggested that we can use article 248 read with entry 97 of the schedule 1, which gives residuary power to parliament, and by using this residuary power parliament can amend the constitution. And the question was asked by the learned councils that if what happens if the whole country demands that there should be a change in the constitution or there should be change in the fundamental rights. Justice Subba Rao suggested again we can exercise, parliament can exercise the residuary power, and they can recall the constituent assembly, and that constituent assembly will finally amend the constitution and amend the fundamental right. Otherwise, under existing provision, under existing constitution, parliament or union government cannot change fundamental right, because article 368 is subject to article 13 clause 2, which says that states shall not make any law which takes away or abridges fundamental right, and the word law also includes Constitutional Amendment Act. Now, this created problem for the parliament, and immediately to undo the effects of Golaknath versus State of Punjab, constitution was amended. 24th Constitutional Amendment Act was passed, which added word power in the marginal note of the article 368, which also added word constituent power in article 368 clause 1, and this 24th Constitutional Amendment also added two clauses, one in article 13 and other in article 368, clarifying that Constitutional Amendment Act is not law within the meaning of article 13 clause 3. So, for the purposes of fundamental right, Constitutional Amendment Act is not law, because Constitutional Amendment Act is superior law which is made in exercise of constituent power. Now, 24th Constitutional Amendment Act was also challenged in the Supreme Court, and a larger bench was created, 13 judges bench was constituted in famous Keshwan and Bharti versus State of Kerala. There was an uncertainty in law, law was not clear, what is the power of the parliament, what is the relationship between fundamental right and power of parliament to amend the constitution. Can Parliament rewrite the fundamental rights? Can Parliament do away with some of the fundamental rights? The situation was not clear, and the earlier decisions created confusion which Supreme Court has to resolve in this famous 13 judge bench case, which is the largest bench in the Supreme Court till now. Now, Supreme Court in this case, taking the help of the text indirectly and applying the doctrine of implied limitation, Supreme Court decided, and Supreme Court gave a new principle which is called doctrine of basic structure of the Constitution. Now, if we read the text of Article 368, we find that it says that amendment of this Constitution, the Supreme Court taking clue from word this Constitution applied the doctrine of implied limitation, and the Supreme Court held that this Constitution means this Constitution which was drafted by the Constituent Assembly. It means Parliament or the Union government has the power. The Supreme Court validated and upheld the constitutional validity of 24th Constitutional Amendment, and Supreme Court also accepted that Parliament has power, unlimited Parliament has constituent power under Article 368 to amend the Constitution, but there are certain parts of the Constitution which constitute basic structure of the Constitution and which Parliament cannot change. So, Supreme Court, while accepting that Parliament has constituent power under Article 368 to amend the Constitution and including the chapter of fundamental rights, so Supreme Court accepted in this case that Parliament or government, Union government can change fundamental right by exercising its constituent power under Article 368, but Parliament or Union government in exercise of this constituent power cannot change the basic structure of the Constitution. Now, the question arises, what is the basic structure of the Constitution that Supreme Court suggested, not clearly identified. Judges suggested some of the portions, some of the parts, some of the principles in the Constitution as basic features, like federalism they identified as basic feature, rule of law they identified as basic feature, secularism they identified as basic feature. But the purpose of discussing this case here is that Supreme Court, in the absence of any express provision, in the absence of any express clear provision of the Constitution, applied doctrine, a principle of basic structure in order to resolve the case, a constitutional case related to fundamental rights and power to amend the Constitution. Now, the next and the last case which we have to discuss in order to understand the policy and principle distinction is the recent case decided by the Indian Supreme Court, which is Sahara India Real Estate versus Securities and Exchange Board of India, SEBI. This was a dispute between the Sahara Group and capital market regulator SEBI, and which arose due to alleged leakage of sensitive confidential communication inter parties and their consequential publication by the media. Now, we have two principles, we have two established norms, that while one hand the Constitution has guaranteed freedom of free speech and expression, which includes freedom of press, and any prior restraint on the publication amounts to unreasonable restriction, which Supreme Court has made it clear in number of cases. Now, on the other hand, Constitution also guarantees that every person has right to free and fair trial, and this is a fundamental postulate of our justice delivery system. Now, what is the recourse when freedom of media, which has been extended to media trials, hampers the right to get a free and impartial trial? A constitution bench of the Supreme Court, finding no applicable rule to resolve this problem, applied a new principle called doctrine of postponement of order, to make a delicate balance between these two rights. The postponement of reporting orders, in the opinion of Supreme Court, is a neutralizing device evolved by the courts to balance interest of equal weightage, that is freedom of expression vis-a-vis freedom of trial, when a credible case could be made that it would serve the cause of justice. When there is no other practical means that is capable of avoiding the real and substantial risk of prejudice to the connected trials, postponement orders safeguards the fairness of such trials. Thank you friends. In this module we discussed following things: what is the concept of the indeterminacy or underdeterminacy or determinacy of the law, what is the criticisms offered by Professor Dworkin on the process of adjudication and his suggestions that how judges decide a case. We also discussed his policy and principle justification with the help of 4 cases, 2 decided by the American courts and 2 decided by the Indian Supreme Court. Thank you.